Thank you.
You are live.
Yeah. So this is Senate Transportation. It is Friday, April 4th. We are here to talk about the use of legal trails. And we have a bill that is S4 that's on our wall. And if you could introduce yourself for the record, we are ready to go.
Good morning. My name is John Echevarria, and I appreciate the opportunity to appear today before you to speak in opposition to S4. I'm appearing today as an individual landowner on behalf of myself and my wife, Karen Pratt, seeking to protect a piece of Vermont's land that we dearly love, to appeal for fair treatment for ourselves and other similarly situated landowners, and to defend our constitutional rights and our private property as we understand them. Apart from my individual interest in this dispute, I bring to the committee some relevant professional expertise. I'm a professor at the Vermont Law and Graduate School. I've been a practicing attorney for more than 45 years. For the last 30 years, my concentration has been the takings issue or constitutional property right more generally. I've litigated takings cases in the U.S. Supreme Court and every other level of the federal court system and in the state courts. I've taught property and land use and written numerous articles, books on the subject. I've testified on property rights issues before committees of Congress and committees of the Vermont legislature. I've earned various awards for my work, including from the Department of Justice for assisting the United States in defending against takings claims, and from the state and local government section of the American Bar Association for the legal advocacy work I've done on behalf of state and local governments. So approximately 10 years ago, Karen and I bought a farm on the Stratford-Tunbridge border, known locally as the Dodd Farm, after the longtime owners of the property. We bought this beautiful farm, which was seriously threatened with subdivision and development, for our own use and enjoyment, to conserve the land and to preserve the traditional farming and forestry activities on the property, to restore and preserve the historic farmstead, and to support public recreation. One of the first things we did after buying the farm was to call up the Upper Valley Land Trust and arrange to donate a conservation easement protecting 99% of the property. Another early call we made was to the Tri-Town Travelers to tell them that the Dodd Farm remained open for snow machine use. Today, we encourage the public to use this beautiful property for snow machining, hunting, hiking, skiing, snowshoeing, and horseback riding. Two of the private trails on our farm appear in the Tunbridge Walks book. Unfortunately, for the last 3 years, we've been engaged in a dispute with the town of Tunbridge about whether we, as the landowners, have the right to determine whether and how to maintain legal trails crossing the Dodge Farm, or whether the town holds this authority. Now, I want to make 3 points about S4 and then offer a comment on the timing of the legislative consideration of this bill. First, S4 would dramatically change Vermont law and seriously interfere with the ability of Vermonters to manage their private property. Today, based on my reading of the law, Title 19 of the Vermont statutes clearly denies municipalities the authority to maintain and repair legal trails crossing private land. The statute mandates that towns maintain class 1 and 2 and 3 roads. It gives them discretionary authority to maintain class 4 roads, and it is conspicuously silent in terms of town authority to maintain or repair legal trails, which are defined as not even being part of the town highway system. The town's lack of authority to maintain legal trails is also demonstrated, arguably even more powerfully, by the fact that in the past, the legislature explicitly conferred authority on the towns to maintain legal trails, but in 1986, changed the law, rescinded that authority. Because the towns lack the authority to maintain legal trails, the owners of the lands crossed by legal trails necessarily hold the right to determine whether and how to maintain the legal trails. I can go into more detail about the history of the statute, why the statute reads the way it did, why the legislature did what it did in 86. But in the interest of time, I'll reserve that if you want to get into that later. In accordance with the legislature's decision to not confer trail maintenance authority on the towns, the town of Tunbridge, over the nearly 40 years since the town first created legal trails back in 1987, has never maintained the legal trails in the town. Instead, in accordance with Vermont statute, Tunbridge landowners have made all the decisions about whether and how to maintain the trails. Now, the landowners have actively maintained some of the trails, either by themselves or by giving permission to volunteers to do so. We and other landowners have periodically cleared legal trails and fallen trees or corrected erosion. A culvert on the Baptist Hill Trail that crosses the Dodge Farm became clogged. The Snow Machine Club came to us and said, we want to fix it. We said that would be great. And they did fix it. Nobody talked to the town because the town had no involvement whatsoever in maintenance of culverts on trails. At the same time, landowners in Tunbridge have traditionally exercised their authority to determine whether and how to maintain legal trails by deciding sometimes to not maintain certain trail segments. For many years, probably decades before we arrived on the scene, the Dodge family did not maintain a portion of the Baptist Hill Trail that cuts through the property and right through the middle of the cow pasture on our farm. And we have continued that practice because we are continuing to graze cows on the property. In another part of Tunbridge, the late Euclid Farnham and his wife Priscilla have for many years not maintained the legal trail that passes right through the middle of an old barn and runs down their narrow driveway. And more recently, we have decided to cease maintaining a portion of the Orchard Trail passing through the Dodge farmstead, which traditionally has been used for walking, but which the town now proposes to open to bicycles, including e-bikes. Now, I've heard it said that maintenance and managing uses are inseparable, but in fact, that's not true under Vermont law. There's nothing strange or unusual about the fact that under Vermont law, some legal trails may be regulated for certain activities, but they may not be maintained. Think about Class 4 roads, which are legally open as highways for all highway uses. But towns are under no obligation to maintain Class 4 roads and commonly do not maintain some or all other Class 4 roads. The situation is exactly the same with legal trails, except that the decision whether or not to maintain the trails resides with the landowners and not the town. S4 would dramatically change the law and in the process unfairly change the rules by conferring on towns new authority to enter onto private property for the purpose of maintaining and repairing the trails. This would seriously interfere with the ability of Tunbridge landowners to live and work on their property. For example, in our case, repairing and opening the Baptist Hill Trail that runs through the pasture for intensive recreation would literally destroy the grazing operation on the Dodge farm. It would seriously interfere with the Farnham's ability to use and enjoy their farmlands. Now, I am most familiar with Tunbridge, but there are many other communities in Vermont that I'm aware of where landowners, in accordance with current law, determine whether and how to maintain legal trails. Stripping landowners of this well-established legal right would cause serious unfair disruption to properties, businesses, and personal lives. I'm aware that the Vermont League of Cities and Towns presented testimony to the committee and supported S4, which painted a very different picture of how legal trails are being managed in Vermont, based in part on a VLCT survey, town survey. I received a copy of that survey report in the context of our litigation with the town of Tunbridge, and I found it impossible to reconcile the statements in the VLCT testimony with the version of the survey report which I have, which indicates that many towns like Tunbridge follow current law and play no role in town maintenance. I've been attaching to this testimony copy of my letter to VLCT, and I previously provided the committee staff a copy of the survey report. The second point I want to make is, apart from the practical harms S4 would inflict on landowners, S4 would result in unconstitutional taking of Vermont private property rights by granting town officials a new authority to physically invade private land for the purpose of conducting trail maintenance. Under current law, town officials cannot enter, or their people they delegate their authority to, cannot enter onto private trails and the land that the trails sit on to do trail maintenance because the town lacks the statutory authority to do so. S4 would change that, would authorize towns to enter private property. This is a straightforward unconstitutional taking. The easiest way to explain this is the government affects private property rights in all sorts of ways. And commonly it affects what people can use their property for. Floodplain regulations, zoning. People complain about that. They sometimes say it's a taking of my private property rights. They're almost always wrong because the government has very broad authority to regulate uses of property.
Sure.
On the other hand, government physical takings, invasions, occupation of private property is the third rail of constitutional property rights doctrine. And when the government said, we are coming onto your property, or we're allowing somebody else to come onto your property without your permission, that is almost invariably a taking. And this is true whether or not the invasion is temporary or permanent, continuous or intermittent. I provided the committee a detailed memorandum on this, and I won't go on except to say that especially in this difficult period in our nation's history, when constitutional rights are hanging by a thread in Washington, D.C. and most other parts of this nation, I urge the Vermont legislature to strive to avoid legislation that would violate constitutional rights. The third point I want to make is that S4 would undermine the landowner goodwill that is crucial to Vermont's recreational trail system and ultimately threaten the existence of the system itself. There are about 8,000 miles of recreational trails open to the public in Vermont. About 75% of these are entirely private land. As many have recognized, private landowners who make their land available for public recognition deserve support from the public and from the state of Vermont. Beyond that is the practical necessity to support landowners in order to preserve landowner goodwill and ensure the continued existence of the trail system. In my view, S4 goes in the wrong direction by attacking private property rights of many landowners who have legal trails on their property, but who also simultaneously grant the public recreational access to their private property. More generally, S4 if enacted, S4 were enacted and private landowners came to understand that state officials, recreation advocates were willing to undermine private property rights in order to promote recreation. Landowners across Vermont would think twice about continuing to allow public access to their private land and setting themselves up for the next possible property rights grant. In sum, S4 would threaten the entire system of recreational trails in Vermont by undermining the tradition of respect for and cooperation with landowners that the system depends on. And the final point I want to make is I think this is a bad bill. I urge you not to proceed with it. But if this year is a particularly bad year to think about going forward, I urge the committee to follow the traditional legislative policy of not attempting to amend the statute, correct interpretation of which is before a court in a pending case. We filed suit in the Tunbridge case in June 2022, nearly 3 years ago, seeking judicial resolution of the proper reading of the statute. In the last legislative session, a bill very similar to S4 was introduced in the House, H370. My understanding is the bill did not move, at least in part, based on the legislature's policy against legislating on statutory questions that are before the courts. Since that bill was introduced, our case has gone all the way up to the Supreme Court. We won a unanimous decision reversing an adverse Superior Court decision. The case was sent back to the Superior Court. The parties have extensively briefed the merits of the case, and we are now waiting for the judge any day to issue a decision. At this point, it seems to me there's no good reason not to wait to learn how the courts actually interpret the statute. Indeed, for the legislature to proceed with this bill now would create a serious risk of wasting substantial expenditure of time and effort by the judiciary or the legislature. I think the whole point of this policy is to avoid that kind of waste of effort. The second point, and I think this is a point that Senator Harrison, you raised in an earlier hearing, that the committee and the legislature would benefit from having the court's decision in front of it before trying to legislate on this topic. Now, you've got competing arguments about what the statute says and different ideas about how it could be amended. Once Judge Corbett issues his decision, you will have undoubtedly a quite detailed, thoughtful analysis of the current statute addressing, well, we don't know quite what, but a variety of provisions that are being debated by the parties. With the benefit of that decision, I think the legislature could do a more thoughtful and more effective job of amending the statute if it then decides it wants to amend the statute. And I take it one of the purposes of the policy of not legislating on subjects that are before the court is to wait for whatever guidance, help the courts may offer the legislature to go forward. Finally, I think the legislature should consider waiting so that better information can be gathered about legal trails. If the legislature had better information, you could better understand how S4 or other potential legislation would affect property owners and outdoor recreation, as well as constitutionally protected property rights. I mentioned my concerns with the VLCT survey and the account of that. But I think the headline for the present purpose is that VLCT mentioned that they've done a survey of all the towns in Vermont that have at least one legal trail, and they got responses from 27% of them. So they were able to provide no information at that time on the 73% of the towns. And so I think I have anecdotal information from around the state, but not comprehensive. More importantly, you don't have comprehensive information. So one idea, formation of a study committee to fill this information gap would be a more sensible step than moving forward with enactment of S4. And with that, I thank you again for the opportunity to testify and look forward to any questions you may have.
Thank you. Go ahead.
Thank you, Mr. Chair. And thank you for your testimony. It's a little awkward since you're in a court case right now. So I'm sure a lot of the points you made, you also had worked on in the court case. So I don't want to ask too much about your specific situation, but I did just have one question around your specific situation.
I know we're likely to talk about the case.
Clearly, yeah. But what is the maintenance that Tunbridge is trying to do?
Well,
And how did it?
well, we don't know exactly what it is. They've talked about a variety of things, about digging ditches, putting in gravel, putting in culverts. One of the concerns we have is on the Orchard Trail, we have the ancient stone culverts, which are just a wonderful historic feature of the property. And it's been said, well, they're not really wide enough. We want wider metal culverts. That's not something we want to see. They've talked about restoring to a usable condition the Baptist Hill Trail, which cuts right through the pasture. Which would effectively, as I say, destroy the viability of the trail. So making them passable with bicycles, certainly.
Yes, that seems to be the main thing. Is there's a really lovely. If my understanding is there's a fantastic bike related event that happens that had hoped to use part of your trails, and that's kind of what kicked this whole thing off a few years ago.
There's an individual who runs a bike fundraiser for a local radio station.
Yes.
Said, I'm going to go use the trail. I mean, the town has never maintained the trails. To this point in the town's history, the town has never adopted a policy or an ordinance affirmatively allowing bicycling on the trails on the Dodge Farm. In the last year, they opened one of the 4 trails in Tunbridge to bicycling, but bicycling has never been an authorized use of these trails by affirmative town policy.
Okay, I guess the reason I'm asking is it's a really strong statement to say the occupation of your land. And I kind of disagree with that characterization if someone's just attempting to move and maintain a trail so that the public can continue to use it. So I think that terminology is a little strong. So I just wanted to make that note. And can you just tell me a little bit more? I'm also not familiar with this judicial resolution idea. I mean, at least in my time, we've certainly made decisions around legislation while there's major pending law cases. So I'm wondering if you could speak a little bit. Did a chair of a committee tell you that that's a precedent we have, or how did that information come to pass? Because I'm not familiar with that. We can ask legislative council, but my understanding is we have completely in our authority to make decisions while there's a pending lawsuit, and we do it reasonably frequently.
Well, you're the expert on that. We're recounting what was told to me about the fate at H 370. I think Ledge Council at an earlier hearing on this bill said, yes, there is a practice of not legislating, matters that are before the courts, but there's no barrier.
Yeah.
No barrier.
Yeah,
I'm not
there's-
claiming there's a
Oh,
barrier. I'm
okay.
just saying it's,
I
I'm
missed
not saying that not suggesting in the least that the legislature is powerless to do that. I'm just saying I just think it's wise legislative policy, which I guess is followed and recognized.
Yeah,
Maybe not invariably, but is recognized as a good policy in the legislature.
Yeah, I guess I just had not heard that, but I'm also not on judiciary. So I don't interact a lot with those kinds of situations with pending law cases. And then I just had,
If I can go back to the
Oh.
invasion,
occupation.
occupation, I mean, no question, based, what am I doing? You know, I can't speak to the policy about how the legislature operates, but on this question of physical occupation,
It's kind of a big
you
statement.
know, this is my wheelhouse, and yeah, when the government comes in with, you know, front end loaders and people with plaid shirts and chainsaws and comes onto private property, that is a physical invasion.
Okay, do you think that folks who own large swaths of property, typically folks who can afford that amount of property, have an obligation when they have property in either current use or have a public trail, a legal trail running through them? Do you think they have any obligation to the community? Yeah. I mean, I can't go, I don't have a lot of money. I can't own a large swath of land. The only way I interact with the outdoors is kind of legal trails in that regard.
Well, not on the Dodge farm. I mean, you know, you're asking, I would say,
You're an expert, so I want to kind
no,
of get your thoughts.
it's a fine question. And, you know, the private property is an important, value, and it is strictly protected and increasingly strictly protected by the US Supreme Court. On the other hand, we all have a social obligation to be neighborly.
Yes, I agree.
And we have done that in spades on the Dodge farm. And all the other landowners affected by legal trails and tundage have done that in spades. As I say, we have told the snow machine people, you can use the mile-long trail that winds all through our private property on the Dodge farm. We've opened the property for a whole variety of recreational uses. One of the reasons we bought it, I mean, I was first inspired by the property when I was visiting the property, and I met a family at White Rock on the top of the hill. The son and his bride had just gotten married at the top of the Ferris wheel in Tugridge Fair. And then the family was going to have a little family celebration, and they went to White Rock because it is an iconic gathering place in the community. And our ambition in buying the property was to make sure, I mean, anecdotally, the story was that somebody had approached Libby Dodge and said, I'll pay you $1 million if I can have a building lot on the top of White Rock. She said, no, I'm not selling it to you. And we didn't want it sold to anybody else. We wanted it to be preserved for the community. And that's what we did. We bought it. We gave away the development rights, and we invited the public to visit it. And, you know, that's, you know, whether that's our social obligation, it's how we want to behave in Vermont. It's how we want to be good neighbors. And we think we've been good neighbors, which was this, and then the town, and then the bikes were not an authorized use. And then the bikers came along and said, you know, this is trail. We want to develop the trails for recreation. We said, well, look, you know, hey, we've given away development rights on 320 acres of land.
Yes.
We've opened 320 acres of land to all sorts of recreational uses. Can you continue to go around our property instead of going through it? And that was sort of the beginning of the debate. And then they said, no, we really just want to go through your farmyard, and we want to go through your pasture. And I thought that was a completely unreasonable position. And I said, and I'm not sure I want to debate your authority to designate uses.
Yeah.
But I look at the statute, you know, as a reasonably well-trained lawyer, and I say, you don't have the authority to maintain these trails. And so, you know, you've got half a loaf. I mean, my view is that the statute, in a very Vermont way, calls for cooperation. It's sort of like two hands clapping. The landowner and the town or recreation advocates have to work in cooperation. And that has worked very well all across the state of Vermont. And that, in effect, is what the legal regime governing legal trails calls for. Now, maybe that means that, trails will have to be moved for the convenience of the landowner, or maybe for the convenience of the bikers.
Yeah.
The snow machine people, we've moved the legal trail on the Dodge Farm 3 separate times
Yeah.
to be adapted. But, as I reread the statute. and-
Yeah, and I think that's why where the bill is here, is I think you're correct in your current interpretation of the law. And that's kind of what the point of the bill is to change that. So I
I
think,
appreciate you saying.
I think
yes.
we're in agreement with that. Like, that's kind
And,
of,
all I'm saying is that based on my, open to contradiction, obviously, but based on my professional opinion, when the government does not have the right to come into your property for a particular purpose. Now, they may have a right to go to walk on the property or allow people to walk. But if they want to come in with chainsaws and front end loaders, so on, and do maintenance, that's a separate easement. That's a separate stick in the bundle of property rights. And it involves physical invasion of private property. That hits the third rail of private property rights and constitutes a taking. And making this unconstitutional.
Go ahead, Lynn.
Thank you, and thank you for being here. So can you speak to not maintaining and how not maintaining overlaps with closing a trail?
Well,
Or does or doesn't? I don't think it has to overlap, but
yeah, I don't
I'd like
think
to
it,
hear from you.
yeah, I don't think it overlaps. I mean, there's a provision in the law that's been in place for some time that says, it's sort of a general provision that says a person cannot block a highway or a trail.
Yeah.
And they can't put some obstacle in the, I don't know, park a truck or rollable
Fence or something.
or put up a fence.
gate.
Or yeah, you can't put up a fence. Or,
Okay.
well, of course, you can go to the select board and say, may I put up a fence? And they may allow you to put up a fence,
Okay.
but without, but that's one, that's that activity. The other activity is, we're just gonna, we've been doing the work to keep this trail clear and walkable and smooth and not eroded, and we're just gonna stop doing that. That's not within the scope of the prohibition. That's just, we have the authority to decide whether or not how to maintain. It's like, I have the authority to decide whether or not to build a house on a building lot. I can build a house or I cannot build a house. We have the authority to decide whether or not how to maintain the trails. We can decide, like the Dodgers did before us on the Baptist Hill Trail, we can decide not to maintain the trails.
yeah.
And can you not maintain them to the extent that
Yeah.
they're not walkable?
Well, I guess that's an interesting question. The millions of acres, several millions of acres of Vermont, rural land are open for hunting, right?
Mm.
Unless they're posted, and that's big
Close it every
hoo-has.
year.
And so, a large, vast area of Vermont is open for hunting. People walk onto the land and they hunt. Nobody maintains that property.
Mhm.
And people have to, they hit low down, they walk around it and so on. So, and I know I sometimes walk on a trail. I enjoy walking off a trail. And so there may be an undeveloped trail that the public has the authority to designate for walking, and people can walk it. I mean, the Orchard Trail now is open to walking, and people walk it. It's not very convenient. We would like to sit down with the town and say, we'd like to continue to maintain the trail for the snow machines, like to resume or maintaining the Orchard Trail, but we've got to come to agreement on, because neither of us can act has full control here. We have to act in concert.
Okay, thank you.
Thank you.
Go ahead, Jens.
I can't find the definition of legal trail for the main one.
Well, it's, the justice of the Vermont Supreme Court asked the same question. What is the definition of
Yeah.
legal trail? And
I'm glad I'm in good company.
you're very, I can't remember if it was, I can't remember. One of the 5 justices asked the question, and he didn't get a very good answer. So let me see if I can improve on it. There is really a definition. I mean, there are a bunch of very limited provisions in the law addressing legal trails. And you just, and those define the legal parameters of what a trail is. You cannot obstruct a trail. If you want to put up a fence, you can get permission from the select board, but you have to ask for it. They're very limited provisions.
Right. So it's because it seems like there's, I mean, you
Excuse
would think
me,
we'd want to define legal trail and want to define recreational trails open to the public. In my mind, those would be two different things,
well,
but it's not clear. That's why you're.
well, when I say, I'm referring to, I guess, kind of an informal, when I say recreational trails, Vermont 8,000, it's sort of somebody's, listing, coding out with all the trails that are available, vast trails, and other trails, lots of them on private property. But legal trails are a very small subset.
We don't know what they are. But we don't know what they are.
No, we don't really know what they are, except the other thing that says they're not highways. Until 86, they were highways. And then in 86, Phil Hoff and others came up with some amendments and said they're no longer part of the highway system.
Trails are legal. They were specific about legal trails.
Yeah, legal trails are not highways.
Are trails?
No, I mean, trails more generally.
I don't know, because
no,
I don't know what the
no.
definition of legal trail is.
No,
Like, what's the difference between a trail and a legal trail?
I think our legislative council may be the way.
Okay.
We're gonna get,
I guess that's
we
what
have a witness in the chair.
My definition, a legal trail is it's listed on town mileage maps and it's designated by the town as a legal trail.
Yeah.
Usually they're old former class 4 roads. And that's those are legal trails. Now, there are many additional trails, including some trails on the Dodge Farm that are used by VAST and
Right.
others. And we all sort of informally refer to them as public recreational trails, but I don't think they have limited, if any, recognition in state law as a system. I mean, there is.
I think for me, that's kind of the key question of what time would the municipality have the right and when they would, because I agree with you about the taking, but not if there's an easement, obviously. So, which I know you agree with, but like folks, so where do you draw that line? Do you need an easement? Or do you just need to have it been on a map at one point as the trail, and that makes it a legal trail? And
Well,
just being a legal trail, I can think in your opinion, it doesn't matter as far as the authority of the town to think, hey,
Well, the town simply, doesn't have the authority. So the legislature would say, well, we're gonna create this new authority and intrude on the private property owner's rights and do it in a way that constitutes an invasion or an occupation, then that would be a taking. Going forward, there are a variety of ways to sort of sort this out. I mean, my view, I know people are concerned, say, well, if the law remains the same, this is no threat to these 500 miles of trail.
right,
I mean, it's worth emphasizing that this is a very limited set of trails. I mean, Senator Clarkson talked about Woodstock. She was head of the Trails Committee, and there were more than 30 miles of trail. 0.39 miles of legal trail exist in Woodstock. So in other words, the vast majority of the trails that the trails group, commission in Woodstock worries about have nothing to do with legal trails.
what are those trails called?
Well, those are either, I don't know, they're either on private land because the landowners have said, you're welcome to use our property, or they could be on town parkland where the town owns the fee and has unlimited authority to allow public access. But they're not legal trails. And, similarly in Pomfret, there what it would be here, more than 40 miles of mountain biking trail in Pomfret and Woodstock. There are only 5 miles of legal trails in Pomfret. Now that's not insignificant, but it's only a fraction. But my sense is that you have to start with the premise that landowners are generous. We think we've been generous, and you look across the state of Vermont, and landowners voluntarily allow public recreation on thousands of miles of trails on private property. If the law remains the same, I think the good folks of Pomfret are going to have to recognize that they've gotten out over their skis and that they've asserted authority that they legally don't have.
Mhm.
I think in practice, Pomfret, a number of the landowners, based on my conversations, who have legal trails, actually do the maintenance themselves. The town has a sort of claim to do maintenance, but the landowners do the maintenance. If the law remains the same, the folks in Pomfret are gonna have to go to the landowners and say,
Right.
we got a little ahead of ourselves. And we just love this trail. And, I talked to one landowner who said, well, we don't really have a problem with the trails and the bikes because we can't see them. and the magic of a trail that works for everybody is the trail that does not invade the house, the homestead. And maybe some of the trails in Pomfret would have to move, but I would predict that all or virtually all of the legal trails in Pomfret would remain open for public use 5 years from now if nothing happened, if this legislation didn't go forward. But I understand the concern because people have assumed, I think, without consulting counsel or without reading the statute, that they had the authority. But I don't think it's going to be the death knell for the use of legal trails in Pomfret and whatever other communities are out there that have gotten ahead of themselves.
Thank you.
I think at this point, we're gonna let the lead talk. We'll get the background from hopefully both sides on this, and then we'll go through the bill with Ledge Council. So if Josh, could you switch chairs? We have to.
And Samantha's gonna join me too.
Oh, thank you.
While we're getting set up here, just introduce ourselves again. Josh Hanford, from Vermont League of Cities and Towns,
And Samantha Sheehan, also from the Vermont League of Cities and Towns.
and also from the League of Cities and Towns, in case you have questions, Cale Romanoff here, who's a municipal assistance attorney. So thanks for having us back on this. Got a PowerPoint here that Samantha put together, and she's largely going to drive, and I'm going to fill in along the way.
So we will start roughly where you left off with the prior testimony, which is what is a legal trail. Legal trails are defined under Title 24. A legal trail is a public right-of-way that is not a highway and previously was a highway, or a new public right-of-way laid out as a trail by the municipal legislative body in order to provide access to abutting properties or for recreational use. I'd like to share some history of some recent history, legislative history, that has contributed to the establishment of hundreds of miles of legal trail in the last few decades in Vermont, which is to talk about Act 178 of 2006. This act required all municipalities in Vermont to map class 1, 2, 3, and 4 town highways and legal trails by 2015. And the same act had another provision that allowed for the mass discontinuation of town highways between 2006 and 2011. Many towns availed themselves of that opportunity and threw up many miles of ancient road, which in those cases, you may see them on your own town maps as a UC or unidentified corridor. In those cases, the right-of-way reverted back to the property where the trail was located, or not back to it, reverted to the property where the ancient road was located. And in the cases where municipalities chose to establish authority over a legal trail, that trail became a public right-of-way. This process was huge. A huge undertaking that took many years and many volunteer hours.
in communities across Vermont. These ancient roads and right-of-ways were researched, identified, included planning processes and mapping. Many towns established ancient road committees who undertook this work and advised their town's legislative bodies on what to do. And by doing so, they established hundreds of new miles of legal trail and new class 4 road. According to VTrans, that period of time, 2006 to 2011, established over 240 miles of legal trail and 148 miles of class 4. ACCD provided grants that funded much of this research work and, GIS mapping and other tools that required local resources to complete. And they actually provided grants to 89 municipalities, although over 100 went through this process of mapping their trails.
And just a side note, I was at ACCD when this was undertaken, and there was a full-time person working with communities throughout this process. It was a lot of work, a lot of effort, state funding, providing staff person and these grants to make this work. To talk a little bit about the legal trails and what they do, although there are a small number compared to the network, I think it's really important that everyone's agreeing on the same number. Mountain Greens Trails and Greenways, VIMBA, VAST, that 75 to 80% of Vermont's trails are actually on private property. And this is a very small but critical access to municipal forests, state forests, public lands that people can access and have multi-use trail networks. It's sort of a backbone of our rural economy to be able to get out there and recreate in our beautiful state. The Agency of Transportation is the one that maintains authority over these mapped legal trails, and they report nearly 550 miles of legal trails. Here's just some examples of communities, from Stowe to Rochester, that showing their miles of mapped legal trails. It's true, some communities have very small amounts, but they also connect to critical other properties. And this little map on the side, which we'll go into more detail, is something that I'm very familiar with. I lived less than a quarter mile from this, and Samantha lives just down the road, a few miles from this. This is in Rochester. The yellow is a legal trail. That legal trail connects to a state wildlife management area where hunters use. They park at the end, walk up a well-maintained legal trail, access a huge tract of public land, go farther up, there's a state forest, and then further along, this can connect to national forests in a very large mountain bike network, the Belmont Trail and such, that numerous resources from the state and feds have invested in that network. But this is a critical connecting point. There's a parking lot and a very important legal trail connector.
Yeah, this actually connects so you can see this is Bethel, Braintree, Hancock. Granville is where it says public land. That's a Granville town line. And so the east side of this trail network connects to a Braintree trail network. This is all the Braintree range. And then these gravel town roads, these are gravel roads. They're beautiful. I personally feel this is maybe the most beautiful corner of Vermont. Can take you over to the west side of Rochester. This is the beginning of the Green Mountain National Forest, and there's long trail access, several trails that access the long trail there. I highlighted in green all of the public lands, and these include state, municipal, and federal. The town with the most miles of legal trail is the town of Chittenden, although the average statewide is about 2 miles per town.
It should be noted that Chittenden, a lot of those legal trails access the national forest and public land, national public land.
This is the information we shared with you some months ago at this point, from our voluntary survey of municipalities. 45 of those did respond. 44 of the 45 had a legal trail that they actively maintained. And they shared some information about the work that goes into that maintenance. In most cases, or in many cases, it's shared and coordinated between the municipality and local outdoor recreation groups and clubs. as well as with private landowners and businesses, local businesses. And in most cases, these legal trails that are regulated by the municipality as public rights of way are open to lots of different uses, including bicycles, snowmobiles, and ATVs. So it is actually, we're going to share a different perspective than what you've heard so far. It is VLT's position that municipalities do have the exclusive authority to maintain legal trails as they are explicitly authorized to regulate them. We believe the legal wisdom or the legislative intent of legislatures past is implied that the exclusive authority to establish and to regulate the use of these legal trails belongs to the legislative body of town and city government in Vermont. And without also being, it would be absurd to have them, to give them the authority to establish and regulate the use of a right of way without giving them the attached authority to maintain them for those purposes. So what we're asking for you to do is to clarify. We come in here a lot, that those of you who serve on other committees, including GovOps, we feel that S4 cleans it up and makes it crystal clear that in addition to the authority to establish and regulate the use of legal trails, that municipalities have the authority to maintain or cause to be maintained through coordinating with other members of the community, these really essential public trail networks. So municipal legislative bodies, I already covered the first point. But municipalities have, of course, under Title 24, oversight over the general supervision of all of the affairs of the town. And again, legal trails as defined are a public right of way. Municipalities that want to permit any type of use, hiking, hunting, cross-country biking, ATV, would all be powerless to do so if a trail falls into disrepair. And as Josh said, more than 70% of all trails, all public trails in Vermont for all uses are located on private land. In those cases, the public does rely on the goodwill of the landowner to coordinate and cooperate and allow access onto and through their private property. That is not what a legal trail is. A legal trail is a public right of way that does not rely on the cooperation of a private landowner. We'd also say, furthermore, state law allows the public use of private land for hunting, fishing, and recreation, and requires that private landowners post so that you have to take an affirmative action to not allow the public on your land. And so in these ways, these legal trails in particular have a rich history in Vermont and are very connected to the culture of our communities and the ways that we use and enjoy the wild parts of Vermont now today. And so with that, we have a little treat here. So we're back to this Rochester Legal Trail. So which way am I facing? So these first two are from VTrans town highway maps. So last year's in 2024. This one is from 1941. For some reason, they're never all facing north. So the orientations are a little bit different. I did the best I could. But here you can see the trail right here. You can see that jog that goes over to Braintree and Bethel. And then here is from the Beers Atlas in 1869. And again, it's right here. You can see right here, the old homesteads and the names. This was E. Cooper right there in the jog. These were used as critical routes for commerce, for families that lived on the other side of the mountain. later to, drive cattle and sheep, later still for logging, and now, foraging, hunting, fishing, mountain biking. I often see ATVs in there.
And, just to sort of sum up, quite the contrary of what you heard earlier, we would contend that if you don't change and confirm that this was intended all along, that will have a dramatic change in the sort of existing practices carried out throughout Vermont between municipalities, landowners, and the use of these legal trails. Quite the contrary, waiting for the courts to decide that and maybe have a narrower interpretation just for a Tunbridge will leave this debate open. When the conventional approach has been, these are legal trails. It's true, they're not required to maintain them to some standard, but when a community interest such as a bike or a walking or a fundraiser decides that a legal trail should be safe for folks to use and they want to invest some effort into it, it'd be quite challenging if every segment of these legal trails that pass through different landowners all decided they like bikes, they like bird watchers. That's not what a legal easement is about. It's about fair access. The town has some oversight, can call upon maintenance, but yet aren't required each year to invest X dollars and put in modern culverts or bring a backhoe up and dig rock line ditches if that's not necessary for their legal use that's gone through a public process and debate. So that's really our overall view that this is important. It's come to practice the way it's viewed now, and not settling this and adding S4 language to the transportation bill would be a real missed opportunity to continue the economic sort of vitality, the investments we've all made in outdoor recreation. There are millions of dollars that we've put into outdoor trail networks that are accessed and in fact use these legal trails throughout the state through the VORAC grants and others. And to put that all in jeopardy is really sort of undermining our efforts and the sort of value we have as a state, knowing we're the second highest state GDP from outdoor recreation in the nation.
Did you say you thought it was defined in 24?
Chapter 19.
I think it's in title 19.
Oh, Title 19.
Yeah. Yes.
Tucker is nodding.
Yeah.
Title 19.
And so title 19 doesn't actually define legal trails, but it does say that trails is a right of way that's not a highway.
I'll say something out loud and see if other people in the room nod or shake their head. In Title 24, where it discusses town highways and the authorities and obligations of municipalities, it is like pursuant to. So trails as defined. So legal trails in that so legal trails there, which is the language that's addressed and suggested to be amended in S4, rely on the definition of the trail. So it's
Maybe I didn't see, they were 24 trails are mentioned, but I didn't see a definition. So I think the issue is, well, one, we keep using the term legal trail, but we don't know what it means. But two, it's like, I think it's really like, is it a right of way? It's really.
If it originally was a class 4 road.
It's like, it's a road that's no longer a road.
It was the process to move at least 2 of us were on that committee in 2006.
Right.
It wrote the legislation.
And I was on the select board when we did the whole. We did the survey in our town and said like, okay, which are our roads and which are our roads?
Mhm.
But it seems to me, which is maybe not really a question, but maybe for our own council of what the definition of right away.
Mhm.
Thank you, Mr. Chair. One piece that I don't think you've spent a lot of time talking about is the implication for towns. Because I do think that what will happen in certain communities is that very specific wealthy landowners will choose to close down
Mhm.
their legal trails. If we don't do something.
Mhm.
And then there will be other folks who will keep them open. And I'm just wondering how, I mean, it just feels like we're gonna end up in a situation with a lot of patchworks that these towns basically have to enter in potentially multiple different agreements with many different landowners
Mhm.
to maintain any kind of semblance of the trail network they had before. So I'm wondering if you could speak a little bit to what would happen in that situation. Would towns have to enter legal agreements with every one of these landowners if this was not clarified?
So one area of concern here is litigation. That's a concern we're hearing already from municipalities, especially those who have invested a lot in both establishing and maintaining their legal trails and where those are connected to critical other access points for public use and public land. We speculate, it's a speculation, but an informed one, that if the court in this case were to rule that municipalities did not have the implied authority to maintain as well as regulate the use of these trails, that really, in order to avoid that conflict, many towns would throw up the trails.
Yeah.
And they would become undefined corridors, which were no longer a public right of way. So the public, in many cases, yeah, there's certainly a serious concern that the public could lose access.
Or in the reverse, if the town really wanted to make sure, they would maybe have to go through the expense of upgrading it to a class 4 road.
Yeah,
Mhm.
exactly. That's
When it's serving the public quite well as a
For a class
right
three.
away trail as understood and as folks have approached it for decades.
And you've heard, I think, a lot of testimony already on the current recreational use and future opportunity of this type of trail. In my neck of the woods, it has happened a few times where municipalities had gone through the process of determining class 4 or legal trail or discontinuing an ancient road and did not maintain them until the point at which the forest management plan came around to logging. And then they would sort of reinvest with the contracted logger to reestablish a safe road that could manage the forestry equipment. Those folks would go in there and do their work and assist with the healthy maintenance of the public land through the forestry plan, leave, sell their wood. And then the hunters and the snowshoers and the dog walkers and the hikers would happily come in and enjoy a nice, wide, safe, easy to use trail.
And then just one final question, since it came up in the previous testimony, there was a bit of back and forth about your survey and if your survey was valid or if you got.
Well, it's voluntary and it's
It was
not,
quick. It was like
Yeah.
a week. We gave them like 5 days to respond, and those 45 communities, sought the desire to respond. And I would trust their information provided that they're working with landowners, they're working with outdoor groups, the type of maintenance that they do, clearing brush, some ditching. I have no reason to believe they were giving us false information on a voluntary survey.
But you also have a town meeting process in a way yourselves. And this was identified with
Sure.
that process.
absolutely, yeah, this
Yeah,
is.
so
an-
it's not, you didn't
Yeah.
bring this up just because you got a survey from 45 people.
Right.
It
Correct.
was, if I understand correctly, you have a process where as many towns and representatives, if you've ever been to town meeting for Vermont League of Cities and Towns, it's quite an affair. It's like the deepest municipal nerds all coming together to debate what all the towns should put out as their platform.
Mhm.
And this was identified through that process as well.
Yeah, this is a priority policy supported by VLCT members. Also, we put out the survey to try to learn more about specifically the maintenance and regulated use of legal trails. It's not a question what the trails are, where they are, or how many miles of them exist. That is cataloged and reported annually by the Vermont Agency of Transportation. Thank you.
Okay. Thank you.
Good, thank you.
Why don't we take 5 or 10 minutes and then we'll come back with the